22-117, Commonwealth versus Karen Reed.
All right, good morning. So we're here on the Commonwealth's renewed motion. Can we turn off one of those air conditioners, please? The Commonwealth's renewed motion for reciprocal discovery and the motion to exclude the defendant's newly provided expert, Dr. Marie Russell. I will hear you on your motion, Mr. Lally.
Good morning, Your Honor.
Oh, I'll hear you, Ms. McLaughlin.
Essentially, the Commonwealth is just seeking that the defendant produce what the Commonwealth is entitled to under Rule 14 and what every criminal defendant in the Commonwealth of Massachusetts must produce to the prosecution. It was not until the day prior to trial on April 15, 2024, that the defendant provided notice of all their experts. During jury empanelment, the Commonwealth filed a renewed motion for reciprocal discovery, and the defendant was ordered within a week to produce the expert opinion testimony that the Commonwealth is entitled to. We are now entering, I believe, week 8 of the trial. The Commonwealth has not received any intended expert opinions, anything that those experts, any written reports, opinions, or anything that those experts have based their opinions on. Essentially, the defendant's strategic decisions not to retain their own expert, but rather rely on the U.S. Attorney's Office investigation does not alleviate them or relieve them from their Rule 14 obligations. As it pertains to Dr. Marie Russell, the Commonwealth did not receive notice that she's an intended expert until about week 6 of the trial on May 21st, and it wasn't until May 30th that the defendant provided a brief synopsis of what her expected testimony would be. Essentially, and looking at the balancing tests set forth by the case law, the Commonwealth was extremely surprised by this disclosure, and further, the Commonwealth would put that the defendant's delayed decisions to produce reciprocal discovery is in bad faith. It is intended to ambush the Commonwealth and conduct a trial by surprise. We are still receiving reciprocal discovery. Over the weekend, we received additional photographs that the defendant intends to use. The Commonwealth is extremely prejudiced by these delayed disclosures. So looking at all the balancing factors, exclusion of Dr. Russell is really the only remedy that's appropriate given that we are in week 8 of the trial. The Commonwealth cannot seek a continuance. The Commonwealth has their hands tied with how to effectively prepare for cross-examination of that witness as well as all the other witnesses. We don't have any materials. We don't know what the experts' precise opinions are and what they were testified to. And it's essentially, it is in bad faith and there's no less severe sanction. So the Commonwealth would move to exclude Dr. Russell. And at this point, we are essentially just seeking the reciprocal discovery that the Commonwealth is entitled to be able to effectively prepare cross-examination of these witnesses so late in the game. Thank you very much.
All right, who's arguing this for the defendant?
There's no mic at council table, so I'm going to go to the podium with the court's permission.
Yes.
We need to be heard on this.
That's why we're here, Mr. Yannetti.
Thank you. I'd like to start with the most outrageous and false assertion that the Commonwealth made in its motion.
Can I just ask you, there's no jury here, can I just ask you how long this is going to take?
Between 5 and 10 minutes.
Okay.
Tops.
Because I don't need, the hyperbole.
Your Honor, I need to make my argument in the way that I think is most effective for my client. I will keep this brief and succinct, but I have points to make that I need to put on record.
Okay, and I'm the person you are trying to convince, correct?
I understand that. The Commonwealth, in a public filing, wrote the following on page 3 of its motion. Quote, during a pretrial hearing on February 15th, when asked by the court whether there was any dispute about a canine's involvement or canine DNA, Attorney Yannetti indicated no, and that the defense was not pursuing such claim. I was astounded to read that for 2 reasons. First of all, it is false. It is a lie. Second, the Commonwealth has knowingly lied about something where it's easily verifiable that they lied. We pulled the tape from February 15th.
I don't have that.
I'm sorry?
I don't have that in my motion.
It's on page 3, Your Honor.
I have the Commonwealth's renewed motion for reciprocal discovery, a motion to exclude defendant's expert, Dr. Marie Russell. I don't see your name at all, Ms. Giannetti. I'm on page 3.
I'm sorry, it's not page 3, it's page 4. My apologies. My name is right there on page 4. It says exactly what I just argued to the court. It's about the 5th line down. It starts during a final pretrial hearing on February 15th, exactly
Okay.
as I said.
Okay?
All right? We pulled the tape from that February 15th hearing. Here is what was actually said. This court asked me the following, quote, while we're talking about DNA, Mr. Yannetti, do we need to be concerned about canine DNA? Where do we stand with that? I replied, no, I think this is the only outstanding DNA issue. The court then replied, okay, so all right, we're not dealing with canine DNA. And I said, no. There is nothing in there, contrary to what the Commonwealth has represented to this court in a public filing, that I said there was no canine involvement. There is nothing in there, contrary to what the canine represented to this court and to the public, that the defense was not pursuing such a claim. Can you imagine the nerve of the Commonwealth to spin that interaction?
This is the hyperbole I don't need. Could you please get to the point?
Your Honor,
We've got a
of course.
jury coming in 15 minutes.
I understand, but this is, my integrity has been attacked. There have been allegations of bad faith that has been attacked, and I need to defend myself and my client. We were only discussing at that time whether canine DNA was still outstanding, and I succinctly replied, no. And they've spun that, or tried to spin that, into a claim that we're somehow waiving our right to argue that John O'Keefe's arm injuries were consistent with a dog attack. And I ask you, have they no shame? I'm sure it's not lost on this court that this false filing by the Commonwealth comes on the heels of their nefarious attempt to pass off an inverted video, a false video, before this good jury hearing this case. Never once during the direct examination of Sergeant Buchanan did they inquire or mention the fact that the video showed
Can we please, all right, I'm going to stop you. Please direct your comments to Rule 14 and the reciprocal discovery obligations that the defense has. That's what this motion is. I know you have a speech you want to make, Mr.
It's
Yannetti.
not a, Your Honor, it's, most respectfully, it's not a speech. It's
Okay,
it's
so-
a defense of being alleged to have committed bad faith.
So you've moved on from that. So please just focus on Rule 14, and let's do it in 2 separate parts. So you've changed, you're not calling Frank Sheridan,
No,
right?
we
You've
are
got-
calling Frank Sheridan.
All right, so you've got a new medical, Dr. Russell. We'll do that part of it separately. Tell me about what you've provided the Commonwealth on Chris Van E.
They've gotten his CV, and they've gotten the substance of his opinion from us. And they've had that for a long time, and the court, I believe, has already suggested that voir dire will be done prior to his testimony.
All right, so it's starting to look like we might need a whole day of voir dire, and I'm trying to avoid that. So is the Commonwealth satisfied that you, when did you provide anything recently since the filing of the Commonwealth's motion, Mr. Yannetti?
Not on Mr. Van Een, no.
What does the Commonwealth have on Mr. Van E?
On Mr. Vanny, all the Commonwealth has is what's contained, the synopsis on page 2, the first full paragraph. We do not know what his opinions are. It says he'll testify regarding his opinions and conclusions about reconstruction and EDR data obtained in connection with this case. He'll testify to chronological data derived from the EDR, including key cycles and triggering events from the time period in question. I have no understanding or information about what chronological data he's going to testify to, what his ultimate opinions are, anything beyond that relatively vague synopsis that does not comply with Rule 14.
Okay.
Similarly, what's outlined in the rest of the motion, that's all the expert evidence the Commonwealth has received from the defense is contained within the Commonwealth's motion.
Okay. So the defense needs to provide, I'd suggest you listen, the defense needs to provide what chronological data Mr. Van E relied upon and exactly what his opinion is. All right? By the close of business tomorrow.
That's fine.
All right? Now, regarding the 3 experts from ARCCA, so I've read that report. I can't tell who does what or what the basis of their opinion is. So what have you provided?
Your Honor, we've provided everything that we know. We've mentioned to this court at sidebar, these experts did not arise from us.
I understand that.
These experts were hired by the federal government, and they provided a report to us pursuant to the TUI request, and it was specifically outlined that and ruled that they could not prep with us for trial.
So I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here
That's essentially it. We've spoken to them only for the purposes of coordination of their testimony and their background. That's it. We have not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have.
See, I don't see that as being, the report, I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify to.
Well,
and you have not complied with your Rule 14 obligations.
We can't, Your Honor. We can't.
So you can't, but you haven't. So I am left with you haven't complied. So we need to get everybody here for voir dire. They can testify in a voir dire, right?
Yes.
We need to do that well in advance of their testimony.
Okay, that's fine, Your Honor.
All right?
Yep.
And now tell me about this ER doc. Is she an ER doc? I haven't seen her. She's not a pathologist,
Well,
correct?
she's a pathologist, but she has a lot of experience in an ER, which is why she has the experience of having seen dog scratches and dog bites and dog attacks.
All right, so this is not somebody that was involved in the federal investigation, correct?
Correct.
All right, so you need to provide immediately. I want a voir dire of her this week. So we can get her here Wednesday, and we want the other folks up here from Pennsylvania this week as well.
Okay, well, we'll make those calls.
So we need to pick a day. How long do you expect the voir dire of each of these witnesses? If, in fact, the defense has not spoken to these witnesses from Pennsylvania about the nature of their opinion, you must want it too, to be able to question them. How long do you expect the voir dire of each of these witnesses to take? I went and told the jury last week, excuse me, last week that we were going to get them this case by the end of the month based on your representations, which included voir dires. It looks like at least a day of voir dire hearings here.
Yeah.
Yes.
At least with regard to the, of course, at least with regard to the ARCO witnesses, that's my co-counsel's bailiwick. He anticipates that unless there are, a substantial number of objections during the voir dire, he anticipates being able to accomplish that between 45 minutes to an hour with each of those 3. With regard to Dr. Russell, we anticipate a half hour. Oh, I'm sorry, there's only 2 from ARCO, that's right.
You're only calling 2? Which 2? Are you calling the 2 that are certified as accident reconstructionists?
Doctors Rinchler and